And you're live.
Good evening, everyone. Welcome to the City of Annapolis Board of Appeals special meeting for September 18th, 2024. The meeting is being broadcast on the City of Annapolis YouTube channel. The agenda for tonight's meeting may be found on the City of Annapolis website. The agenda contains links to the City of Annapolis YouTube channel, also to the comment form, which must be submitted by anyone who wishes to submit oral or written comments, and also to the city's database for information about cases coming before the board tonight. Written comments received by noon today and matters before the board this evening have been provided to the board and the parties and will be made part of the record. As usual, I like to start by reminding everyone that communications with the board, any members of the board, about any case by anyone other than a party to the case must go through the comment form. Do not contact any member of the board directly. All communications by parties to a case must go through the board liaison, Kim Consoli, in the Department of Planning and Zoning. No one should ever contact any member of the board directly about any case. So we'll begin by asking Ms. Consoli to call the roll, please.
Mr. Gallagher?
Yes.
Mr. Hector?
Yes.
Mr. Walsh?
Yes.
We're expecting Mr. Zazali any minute. So currently there are 3.
Are we expecting Dr. Chen tonight?
No, sir. She's overseas.
Oh, okay. I missed that. All right. The agenda, we'll turn to the agenda. I assume you've had a chance to look at it. I would prefer, if it's all right with my colleagues, to move the Moss Haven Court item to be the last one, because I think it's going to take a little bit longer than the others. That means Melinda would be first. We can do that as a courtesy to the older woman, because that will go very quickly. Any other amendments or corrections to the agenda?
I move that the agenda be accepted with the amended, with the change.
Second.
All in favor?
Aye.
Aye, thank you. We also have on the agenda for approval the draft minutes for September the 3rd. Are there any corrections or additions for the draft minutes for September the 3rd?
I move that the minutes of September 3rd be approved.
Second.
All in favor?
Aye.
All right, we come to Melindo. Melindo Restaurant has applied for a special exception to allow expanded seating, a bar, live, non-amplified music indoors, and seasonal outdoor seating for the restaurant located at 2334 Forest Drive. This has been continued from our last meeting. The city and the applicants have made their case. We've received public comments, including from the older woman, and we will make a decision tonight. I think it seemed pretty clear that we were on our way to granting a special exception, and the question was conditions. The staff report omitted the usual 3 conditions on trash, noise, and loitering, but Mr. Meekins agreed to put those back in. I don't think we had any objection from the applicant. But the board also suggested that we consider a new condition we haven't seen before that would establish an enforcement mechanism for any conditions that might be contained in special exception. And Mr. Hyatt for the applicants has provided his thoughtful comments on the proposal. Negative, I think, would be a fair way to characterize them. Curiously, we haven't heard from the city. Does the city have any comments on the suggested enforcement condition?
So Chairman Gallagher, obviously there's some communication going on between the applicant and the city. And specifically the director, Mr. Jakubiak, was in communications with Alan Hyatt, and generally in agreement with Mr. Hyatt's letter and his email. And I might add that there are mechanisms within the zoning code that would be similar to what you had proposed or what the board had proposed, but there are provisions in the code that any complaints would be registered with the city planning and zoning, and then our code enforcement officials would then handle those complaints and or violations.
Mr. Meekins, are those provisions in the code new provisions?
No, sir, not that I'm aware of. Unfortunately, I do not have the chapter and verse for those provisions. But I mean, my office is right next to the code enforcement officer, who is full-time, probably greater than that, visiting various both commercial and residential properties, and logging and following up on, I'll just say generally, complaints.
Mm-hmm. But whatever mechanisms are in the code apparently haven't prevented the kinds of anecdotal complaints the board members have heard from members of the public about a lack of enforcement.
I cannot speak to that.
So if someone files a complaint about noise, the code enforcement officer next to you goes and investigates that. He doesn't refer them to the police department.
It depends on obviously the hour. A lot of those complaints do go to the police department. We do have a code enforcement official that is working at night, specifically and mainly on the weekend, that accompanies not only the police, but also fire for various complaints, depending on where and what they are.
Mm-hmm. And so if someone calls at night and will they be automatically redirected to the police? Do they get an answer if they call at night? Call code enforcement at night?
I don't think they get an answer, but I am not 100% sure. Generally, you know, those commercial complaints, you know, the first inclination for people to complain typically doesn't go to the city of Annapolis. They typically go right directly to the city of Annapolis Police Department.
And is there any mechanism for the inspection officer at planning and zoning to be informed about noise complaints to the police in cases where there are special exceptions?
Yes, they are available to accompany the police and vice versa.
But if someone complains to the police because they don't get an answer at planning and zoning, will the police automatically notify planning and zoning that there's been a complaint?
Yes, the complaints are, planning and zoning is notified. And a lot of times what happens here, and I'm speaking in general terms, is that complaint would come into the police department it would be transmitted to planning and zoning, code enforcement officers. And then that establishment is then on the radar. So essentially, and generally speaking, the first offense or the first issue, it might not be fully documented, but once that establishment is on the radar, then they're looked at and they're under the watchful eye of code enforcement.
Okay. Questions from Mr. Hector, Mr. Walsh?
No, I see that Mr. Sazali has joined us.
I'm good.
Yep,
I
I've
was
been
concerned-
listening the whole time. I was on as a guest and then finally got upgraded to panelist, so I've heard just about everything.
Hector?
The question was, I was thinking the same thing, Bob, about the noise and the ordinance as far as code enforcement or do the police react. But it was answered for me.
All right. So what do we think? Anyone want to stick their neck out? Chris, you've got the longest experience.
I am the lack of procedure or policy on this subject has plagued this board since my early days. We go about our business conducting hearings, approving special exceptions and variances with conditions, and they leave us and go out into the world and become real projects and real businesses and real things. And what happens? And I'm convinced by the testimony by Mr. Meekins that what happens next is opaque at best. And that's probably not this board's. It's our burden or our I don't know what the right word is. It's our frustration, but it's not our privilege to do anything about it. I wish there was clarity and a process and articulated consequences for violations at each step and at what violations, but there doesn't appear to be. So I don't have an answer. I don't have a crisp thought for you, Mr. Chairman.
Mr. Hector, did I interrupt you? Were you about to tell us where you are?
No, go ahead.
Mr. Walsh?
Yeah, following up on Christian's comments, we've gone back, we've circled around this issue. I think just last year we were looking at another project over off of College Avenue. There was some question, we were trying to figure out a way that we could make some of the conditions enforceable and ultimately dispose of the matter otherwise. But we kind of circle around this, and it is frustrating that we don't have the ability to kind of be able to push the enforcement powers to ensure that these conditions are met. But since we don't have that authority, I look at the application in front of us. I sat on the previous application that was turned down, and I think that the applicant has shown extraordinary, certainly followed what we suggested to him, that he do reach out to the community, make changes, adapt to the community wishes in terms of noise. It seems to be showing good faith in terms of improving the parking lot and some of the other facilities. So I'd be in favor of it.
Mr. Hector?
I'm in favor of it.
I don't know. Mr. Hyatt makes two arguments. The typical parade of horrors that will ensue if we take this cat out of the bag. And a lawyer-like argument that we don't have the authority to do this. And I'm not convinced by either. But I don't want to pick on this particular applicant. I think they have been conscientious. And I've learned a little bit more about the process inside. the mysterious black box called Enforcement Department. And we've got essentially a new director of planning and zoning. So I guess my inclination would be we've laid out a potential solution to this problem, and even if we don't adopt it tonight, it's available to us in the future if we don't feel like our conditions are being enforced in a reasonable way. So I guess I'd be for giving the new director and the Office of Enforcement another chance to do it their way before we try to make them do it our way. I mean, our way is not going to work very well without their cooperation anyway, but I guess that's where I am.
I think, Mr. Chairman, we must default to our primary position, which is to take each case individually and use our best judgment, given the facts before us, and do we feel it's an appropriate decision, right? That's really what it comes down to. And
That's a good reminder. We're not a policy-making body.
Right.
Well, if it was 2-2, which is what it looked like, it's not going to go anywhere.
You don't know how I'm going to vote. You don't know how any of us are going to vote.
All right. Does somebody want to make it? Well, another way to find out is who wants to make a motion.
Rhonda's got a hand up.
Alderwoman, we typically don't hear during deliberations.
Okay, that's fine.
No offense, but that's the practice.
That's fine. Okay. I was gonna say something good, but that's okay.
Everything you say is good.
No, okay, thank you.
So I'll make a motion to go ahead and vote now.
And the motion would be to vote in favor?
Yes.
All right. Is there a second?
I'll second.
All right. All in favor?
Aye.
Can I hear the motion read out, please?
Yes, please.
A motion that we vote in favor of this.
In favor of the special exception with the 3 additional customary conditions and the new enforcement
And the
condition.
new enforcement provisions, yes. Yes.
So that's the motion. Everyone understand it?
Yes.
Yeah.
All in favor?
Aye.
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 Is that Christian?
I'm voting in the affirmative. Aye. Yes.
All right, I'll join you. We'll see what happens.
See what happens. Exactly.
More work for the lawyers. All right, thank you very much. So
Now, would the Alderwoman like to say something now, or now that the
yeah,
record's-
sure.
Certainly. No, what I wanted to say is there have been issues in the past. And what I generally look toward is what the residents are saying. But Mr. Samaran and his organization and his business, based on what the residents are telling me, things have greatly improved. And I do believe that they are sincere. The residents who were very vehemently against it years ago have, based on their testimony that we heard at the last hearing, are confident that we can move forward. I do believe also that we can work with Mr. Hyatt, and that I've always worked with my high school classmates. So that's always a good thing. But also, I'm extraordinarily, I want to say, extraordinarily impressed with our new planning and zoning director. He came in last September the 11th, and he has shepherded us through that comprehensive plan like I've never seen before and got 9 people on board. So I'm confident that we can move forward, and with the measures in place that have been put in place, that we can have a great relationship, and to continue with the relationship with the restaurant and with Mr. Freddie and his son Harry.
One
Well, I
question
hope-
for the older woman. Would you want to get what class on the record that was? All right, question withdrawn.
I appreciate the remarks. I hope you're right. I'm confident you're right. And our experiment tonight will become a
That's all right.
historical footnote.
Good. Alderman Arnett is on, so I just wanted to let you know. So I
Well,
don't know what
his-
you're here for,
his-
but
The action for him starts next.
thank you
you.
all so much. Enjoy the rest of your evening. I appreciate it.
Thank you.
Thank you, Rhonda.
All right, thank you.
All right, we're moving on to Appeal 2024-002. That's 518 6th Street. The appellant Jane Lawrence and others. Quoting again from their notice of appeal, the undersigned appeal decisions and actions of the Director of Planning and Zoning under Section 2130.020A in approving the site design plan for and in the permitting of the construction of a single-family residence and garage located at 5118 6th Street. Appellant's alleged director made errors of law and fact related to height and mass in both the site design approval and in the permitting of the plans, and errors in the construction permitting process. In addition, the director erred in acting in an arbitrary and capricious manner and in an abuse of his discretion. Okay, so let's, we have appearances in this tonight. Do we have counsel for the appellants?
We do have counsel for the appellant, Sir Grant Keel, on behalf of all the appellants. If you want me to read off their names, I can do so, but I believe that's in the appeal.
No, that's fine. And how about for the appellee?
Jessica Carres on behalf of the Department of Planning and Zoning.
Do we have anyone representing the applicant? No? Okay. So the appellants have filed a request for supplementation of the record. We talked about last time whether the record was adequate. The director has responded. The director's response indicates that he agrees in part and for the most part for the rest, which really reads more like a demand for discovery than it does like supplementing the record. And of course, you know, we don't have discovery in cases before the Board of Appeals. But the director's response indicates that much of what the appellants would like to see is available to them in hard copy. So most of what appellants have asked for relates to whether the director acted within the law or arbitrarily or capriciously. And before we spend more time pulling on that thread, we really need to address the legal issue of the timeliness of the appeal. The appeal was filed on July 19th of this year. The specific action appealed from the site design plan approval took place in 2021, I think it was. But appellants wish to make an equitable case that the 30-day appeal deadline should be extended or tolled because they had no reasonable way of knowing of the defects in the director's approval process until June 25th of 2024, they say. So there's a clear timeliness issue. If the timeliness issue is resolved in appellant's favor, then we get to whether the approval of the site design plan was supported by the record. But if it's not, we don't get into that. So typically at this stage of an appeal, we would see, and in these circumstances, we would see a motion on behalf of the director to dismiss the appeal for untimeliness. I don't think we've seen anything. Is there any interest on the part of the city, Jessica, to make such a motion?
Absolutely. The city would absolutely like to make a motion to dismiss for untimeliness of the appeal. Um, at this time, we have not done that formally and in writing, but we did kind of mention that initially in the last hearing. I wasn't sure if that was something that we were going to talk about tonight, or if you guys wanted to talk about the record itself first, and then we could go into motions.
Well, what this additions to the record controversy has demonstrated to me was that's a very complicated process. It's peeling layers back on an onion. And if we don't need to get there, then there's no point in wasting everyone's time doing that. So, Jessica, when would you like to submit your motion?
Could we have 2 weeks to submit it? So it would be the 2nd of October.
2nd of October.
When does the board plan to meet again? I can.
The 1st of October.
We're meeting on the 1st.
Okay.
And we also have a second meeting scheduled on the 16th. Counsel for our appellants, how much time would you need to respond?
Well, sir, normally responses for motions to dismiss in court would be 2 weeks, so I'd be all right with that. I don't think if we are going to have motions before with both parties before the board and time for the board to consider them legally, that we're going to be back here to consider those motions until the beginning of November anyway. Unless the city wants to submit their motion earlier, and then we can try to get in on the second hearing in October. Either way, we would ask for 15 days.
Kim Consoli, what's any idea what our agenda looks like for November 6th?
I'm pulling it up right now. Give me just a second. The date again, November 6th.
Yeah, it's the
That's
day
right.
after Election Day.
After Election Day, yeah.
Right. That agenda at this time only has a status conference on another appeal.
Yeah, okay.
Mr. Chairman, are we moving to that Wednesday, or I thought there was,
We moved it to Wednesday, Christian, because Tuesday is Election Day.
right, so is 6th the Wednesday?
Yes.
Okay.
Yes.
Just wanted to be clear on that point. Thank you.
All right, well, let's go for a resolution on November 6th. So let's give the city a little more time. Jessica, you suggested October 1st. Why don't you take until the 4th?
Okay.
And then we'll give the appellants 2 weeks, or give them until the we'll give them 3 weeks. We'll give them 3 weeks as well. Can we do it by the 23rd? That would give us a week to consider it.
I assure you I can do it by the 23rd, sir. That's not an issue. You're already
That'd
giving
be
me more
great.
time than I expect.
That would be great. And there was a dispute, a motion to strike the demand for more information. We're going to deny that, as has been pointed out. Having said that, everyone should try to file by the 30th. Anyway. All right, so we'll do that. We've got those deadlines, Kim.
Yes, sir, I do.
All right, is there anything else we need to take up?
Not on behalf of the city.
We don't have anything at the moment if you're going to consider motions first.
Yeah, great. All right, well then, thank you very much.
Thank you.
Thank you.
And I will see you in November.
Thank you, Mr. Chair.
Have a nice day, sir.
Thank you. All right, that brings us to our last item, variance 2024-007. Variance application by Mona Design Build, Inc., property owner, to remove 12.25% more of the developed woodlands that allowed 30%, than the allowed 30%, for the construction of a new single-family dwelling on an existing vacant lot on property located at 1009A Moss Haven Court. This one also continued from July 2nd. So we left open the record for the limited purpose of allowing parties to submit by August 30th professional opinions as to certain trees, and for the applicant or the city to provide a clear explanation of which trees would be removed and why. The protestants submitted their materials on August 30, and the city and the appellant has submitted their responses substantially out of time. I was confusing this with the last case. The protestant has filed a motion to strike. Sorry. There's been a motion to strike the protestants on timely submission. And the applicant has filed an opposition to that. And the applicant and the city excused their late filing by pointing out that I said I wanted them to try to submit things by August 30. I didn't say it was a firm deadline. Well, they got me there, but I won't make that mistake next time. And I'm sure they tried very hard to meet the deadline. So I'm going to deny the motion. And so we have new materials that have been submitted. And I think maybe the best way to proceed would be to review each of those new submissions briefly and give the members of the board a chance to ask questions about them. Does that sound good, colleagues?
Sure. Yep.
Yeah. Yes.
So first we have a forester's report submitted by the city. And Kim or Jessica, whoever would like to speak for the city on this, if you'll correct me here. So the 49-inch tree that's referred to in the forester's report is the tree that's on the subject property, the Mona property. Is that right?
Yes, and our city forester is here tonight, and I'd like him to speak on behalf of that because
Well,
he's at the site.
We're not opening the record except for questions by the board.
Okay, well, I'm sorry, you said that it was his report, so I wanted to make sure.
Yeah. Well, if you need to consult him, you can do that. And he said that that maple tree, which has been sort of the focus of the controversy, is in fair condition. I think that's right. But, maybe he could speak up if I misstate what his report said. And the report makes no mention of any need to remove the tree to avoid a risk of injury or property damage. The report does not opine on the condition of the maple tree and the two pine trees on the protestants' neighboring property. That's right. There's a reference in the last line of a need to protect the critical root zone of adjacent trees. And is that, I guess my question is, does that refer to the root zone of adjacent trees on the protestants' property?
Hi, Chair. This is Brian Adams with the Planning and Zoning. So just a couple clarifications. The original memo that I sent back in July, there was a follow-up to that where a further evaluation of that 49.5-inch silver maple was done. And we pulled back some a covering that was put on that tree at one point and discovered more decay. So I would rate that tree in poor condition at this point. And regarding the trees on the adjacent property, yes, that last line is referring to the trees on the adjacent property, not the property of that we're discussing the variance for.
Okay, poor condition, but is it the arborists for the applicants assert that it's a danger and should be removed immediately? Is that your opinion?
I don't think it's a danger because there's nothing on that lot right now. But I do think that it would not tolerate any sort of disturbance and that it will, it is ultimately on its way out. It won't live a very long life. It's in very poor condition.
That's true of some of us.
Right.
Okay. Now, the reference to the need to protect the critical root zone applies to the trees next door. But the staff report, Kim, does not recommend any particular conditions for protecting the root zone of the trees next door.
No, because that is a typical comment that Brian makes with every grading permit that comes in for a new house, because the city has a lot of narrow lots. There's a lot of trees on neighboring property. So this is a standard comment that he makes and requires with every grading permit.
And does Brian go out and check when they're actually doing the root pruning?
Yes. Or he can speak for himself. Sorry, Brian.
Yeah, I won't say that I'm out on 100%. What I do is usually talk with whoever the project arborist is and coordinate with them, and usually at least get some photos if I'm not able to be there that day to show that they're doing what they're supposed to be doing. Yeah. Okay. But I do evaluate all grading permits whenever there's tree protection needed.
Okay, questions from the board on the forester's report from the city?
No.
Now we have 3 arborist reports from the applicant, as well as a new drawing that it's an expansion of the old drawing, I guess. So the large maple tree on the adjoining property, I have it right here. Let me look at it.
Mr. Chairman, is that the one from Chesapeake Arborist that has the photos with it?
It's one of 2.
Okay.
At the top, it says Giddings property, 1011 Moss Haven Court. The other one says Mona property, 1009 Moss Haven Court. So looking at the one that says Giddings property, it says that the maple tree has 3, this is a new term for me, conjoining unions, posing a safety hazard. And when I look at the photos in my pile, the last photo shows 4 principal branches leading out from the main trunk. Can the applicant tell us if those 4 branches lead down to the 3 co-joining unions? Is that what we're talking about?
I think that would probably be better addressed by Mr. Petticord, who is present here on the Zoom. He's the author of this report. My client is not an expert in the field and can only address the report as it's written.
Mr. Petticord.
You're muted, Mr. Petticord. You're muted, bud.
All right, got it. So the maple tree in question is the one on the neighbor's property. It's a larger silver maple. It's already got one union where it's been broken off closer to the house. There's already pictured damage on that side, and there's.
Wait a minute, let's look at the pictures here. I'm looking at the report that says Giddings property, silver maple, and the last photo is this one.
Yep.
Number 4.
Yep. The one lead in the back. There's one small lead in the back. There's 3 main leads that can join down to that one, the main stalk of the tree, and that's where usually the weak point of the tree is usually in that joint.
So it's where those main leads come together.
Yes, sir. Where they all can join.
those are the co-joining unions.
Yes.
And I can see from this picture, there are 4 main leads, so there'd be 3 co-joining unions.
Yes.
Okay. And it recommends immediate removal to mitigate risk of injury or property damage. And then we have another one from you that addresses the maple tree on the Mona property. And that, the photos in that one. Looking at the only photo that you've attached that shows what might be the co-joining unions is this one. Can you see that one?
Yeah, that on the Mona property, there's 3 spots in that tree. That's one of the spots where we removed. There was a metal shield over top of that hole, and it was full of dirt, other debris, lots of signs of rot present in there. There was another larger one on the bottom side of the tree. It's just full of mud and decay. Spots for moisture and insects to get in.
Okay. Okay. I think I understand that. And again, you recommend immediate removal to mitigate risk. And then the 2 pine trees. You say that there's structural weakness and imbalance, high likelihood of failure, and they constitute a hazard. You don't go so far as to recommend immediate removal.
They're not in the worst shape possible, but it's location wise where they're located so close to the house, and with the new construction, it's going to be a conflict in the future with the trees being so close to both properties. Pine trees aren't the strongest trees out there, so they have shallow root system. So, with the construction, it could lead to failure in the future.
So if there wasn't going to be any construction, if that lot was going to remain vacant, would you still say that they're hazardous?
Well, they're just in a bad location, so close to a house. Usually we try to, we remove a lot of trees that are closer to residences just because of, when you have storms, wind blows them over. It's not a good access point. And they're shallow rooted trees.
So the hazard would be to the house that's already there.
The house that's already there. Yeah. I mean, if it was going to fall in that lot, it wouldn't damage anything, but it's just a risk to the house that's so close to.
All right. The board members have any questions?
Yes, I do. Mr. Petticord, this photo right here, let me see if I can get it close. Can you see that?
Yeah, that's one of the rot holes on the silver maple on the Mona property.
How deep is that hollowness?
It was about, I'd say probably close to 10 to 12 inches inside. Is a good sized cavity. You could probably stick a basketball inside there.
So let's say in the next 2 weeks, a named storm hits Annapolis, 50 miles, 60-mile-an-hour winds. Yep. Would it take it down?
It's always, yes, it's a weak point. It's always a possibility when you have high winds, depending on which direction the winds are coming from. It can split it apart. It's just a lot. Okay. Yep.
All right. Thank you.
All right. Any other questions for
the pine trees, the 2 twin pine trees? How far away from the foundation of the existing house do you estimate them to be?
I think they're within 3 to 4 feet of the structure.
And then the typical, that type of pine, what is if it was left to grow in the wild without any encumbrance, what would be the diameter of the normal root ball? The root reach, not just the ball,
the root structure.
Root structure, yes.
It's typically like 1.5 times the diameter of the tree. So, I mean, you're probably talking a tree that size, you're probably talking, it's probably 7 to 8 foot away from the base of the tree there.
So do those trees know that house is there? Have they?
They will grow to the foundation of the house. What they do is they grow to the foundation and then they'll actually turn and start growing down the foundation. They don't.
And do you suspect that's the condition presently?
Oh, I'm sure if you were to dig along the foundation of that house, I'm sure you would see roots present up against the foundation.
And there are wires there, right? Am I seeing wires?
Power lines to the left of those trees.
Whose power lines are those? What property do they serve?
I am not sure about that. there's a pole in the corner of the property. I'm not sure where they supply.
Okay,
They run parallel to the house.
then we'll just leave it as unknown unless anybody knows where those lines, who owns those lines, what they serve. Does anybody know? City?
I can just tell by the appearance, it's owned by BGE, but whose
Well,
house?
I understand that. I'm
Yeah,
asking
yeah.
whose service is it?
Mr. Board Chair or Mr. Board Member, Mr. Zazalia, I believe my client knows that answer.
Sure, go ahead.
So the wires from the pole in the front right corner of my property go to another BG&E pole that is to the back right of
Okay.
my property.
So they're just on a BG&E right of way.
Yes,
Correct.
that's correct.
So in the absence of a new house, those trees are sequestered between BG&E aerial right of way and this other house. So a new house doesn't make removal of the trees any more or less complicated. Does it? I guess that's a question for Mr. Petticore.
What was the question again?
Because these trees exist in a condition that is 3.5 feet away from an existing house and about what appears to be from the photographs, the same distance from existing BG&E wires, it's a tricky removal whether a new house is added or not. Is that?
That's correct. Yep.
Okay.
The power lines there in the house, the structure, it's a tight removal because when you're removing a tree, you have to have places for the logs to fall down to be lowered to the ground. So it's a tricky removal either way, whether there's the house is there or not. You have the power lines and the structure, so it's always a difficult removal.
Okay.
Mr. Gallagher, may I hop in for one moment here?
Yeah.
I didn't quite realize that tonight's session would be, and I totally respect the board's ability to ask questions of present witnesses. I didn't realize there'd be so many facts being thrown around at the moment. I have a report which I've submitted through an expert arborist, which suggests, first off, that those trees are not 3 feet from the existing foundation. They're nearly 6 or 7 feet. They're an additional 6 feet from the property line, which is 6 feet from the proposed foundation. It's totally inconsistent with what this expert before you just told you. It's represented in the report that I submitted. Conveniently, I don't have a live expert here to testify to what he submitted.
That's all right. We have your expert's report. All right. So, any other questions for Mr. Petticord? Or...
All right. I do, Mr. Chairman. Yeah, Mr. Petticord, have you had a chance to see the appellant's arborist report?
Yes, I have.
And what would be your response to that?
I mean, it's fairly accurate. It's fairly accurate. I mean, it's like I said, the pine trees, they're not in the worst condition as far as health. It's more of a location thing. The silver maple in the back of the property, I think, whether there's a structure there or not, it's still a difficult removal. I think, with the location of the tree, it's on the silver maple in the back, there's already been a large branch that has been removed, which it looks like it was ripped off in a storm. So, I mean, that tree's already showing stress.
So it'd be a reasonable conclusion that construction being done in the area of those trees alongside the property line would have an impact, correct?
I mean, it's within the critical root zone of the tree.
Yeah.
But the silver maple is already showing signs of decline. Nothing that's going to be, soon, but down the road, it can become an issue.
Thank you.
Okay, so now we'll move on to Mr. Fulton's arborist's report. And so correct me if I'm wrong, Mr. Fulton. So the pine trees are in good condition. The maple tree has some problems. That the proposed work could damage the pine trees and cause them to fall. None are high-risk trees, but could die or become high-risk trees if the project goes forward. If work is to go forward, root pruning should be done by a certified arborist. No live foliage removed. So let me ask, would the 20 to 25% limitation on root pruning in the critical root zone that's been mentioned in the pruning plan by the applicant. Is that, would that address the concerns?
I have to note objection, unfortunately. Just for the purpose of the record, I have to note objection that Mr. Fulton's not a witness to this matter. He's not an expert. He's the attorney.
All right, thank you. I get it.
I would actually, Mr. Gallagher, agree with Mr. Scruggs. I'm not an expert. I'm not a tree expert, and my certified arborist, Mr. Black's not here. I think can I add just one thing, Mr. Chairman? There is commentary from Mr. Black about root pruning, and I would suggest that the board take that comment not as a direction, but a suggestion. Should, and I'm by no means advocating this, should this development go forward, certainly root pruning must happen. But as indicated in this report, the proposal where this foundation is proposed clearly would have an adverse effect on Ms. Lester Giddings' property.
Okay. All right, so let's get to what seemed to have been the biggest concern when we were here before, and that is what is proposed for removal and what will stay in place. So we've got this expanded drawing. It's a little bit easier for us to read. So if Mr. Scruggs, you or your client would like to take us through exactly which trees are going to be removed and why.
Sure. I think Mr. Forgan's probably my best witness to talk about that because he drafted this document and the author of it. So I'd like him to kind of explain what he did to expand upon what was previously submitted to the board.
All right.
Good evening. So, pardon my voice, I'm a little under the weather today. So what I did was color-coded the canopy cover that we're proposing to remove, canopy cover that will remain from neighboring trees on the site. I also, so the canopy cover that's being proposed to be removed on site is the, I don't know how your print came out, but it's the reddish pinkish color. That's the area of canopy cover being removed. The green cross-hatching, that is the canopy cover from the neighboring property. That canopy cover obviously will remain. So those are the two areas that are color-coded on that plan that you're looking at. I also give a percentage of canopy removal within the requested total removal that's being requested with this application.
Okay, so which trees are proposed for removal?
So the trees that are proposed to be removed on the plan, I highlighted or colored in the tree, the trunk itself. So it's the 45.9 inch tree, the large tree in the middle of the lot that's in question.
And Mr. Chairman, that's the pink circle.
Yeah, we got it.
Yep. Then there's some trees in the rear of the lot that are to be removed. There's one 15.3 foot tree in the back of the property where the stormwater management is proposed. There's some canopy cover from that's being removed, as well as some lower vegetation, as well as another 15.3 inch tree. The diameter of the tree are called out just above the tree trunk that's shaded on the plan.
Okay. So the large maple that's on the property covers what, close to half the lot, or 40% of the lot. And that would be removed. But you need to leave 58% of the lot covered. And that coverage comes from the neighbor's tree?
The canopy cover, yes, comes partially from the neighboring property, as well as the other that's remaining.
So Kim, help me here. They're going to remove the big maple that's on the subject property and a couple of smaller trees in the back. And they're going to rely to get up to their 58% on the tree cover from the trees on the Giddings property, which Mr. Petticord said should be taken down immediately.
That's sounds like what they're saying. But there are other trees, I think, on the property that are remaining that are overlapping those also.
That gets you up to 58%.
That I don't know.
But it must be the position of the department that you could clear all the trees on this lot if you could find 30% coverage from the neighbor's lot. Is that right?
It is about the canopy coverage.
Yeah, okay, I just want to understand that. Questions from other board members?
No question.
No, you said it very well.
Okay. All right.
Bob, I have one quick mathematical question, and I don't want to presume I'm reading it correctly. The pine trees, what is the proposed distance from the proposed dwelling to the existing pine trees? And how does that compare from the pine trees to the existing dwelling?
I believe Mr. Forgan can testify to that, but I think it's a distance of anywhere from 3 to 6 feet. If I'm
To 12 feet from my proposed dwelling to the pine trees.
Okay, perfect. Thank you. And we just heard that from Mr. Fulton that you think it's 6.5-ish from the pine trees to the existing building?
Yeah.
Yes, that's correct.
Yeah.
I just wanted to understand that relationship. Okay, thank you.
Any other questions from the board?
No, sir.
All right, so this is where we would deliberate. Are we ready to deliberate? Anything else you think we need to address before we make a decision here?
Mr. Gallagher, are you offering us a chance to speak, or are you going to dive right into deliberations?
That's the same thing.
I'll give you each 5 minutes.
I don't think I need 5 minutes, but if you'd like me to go first, I certainly will.
Go ahead.
I'd be remiss if I didn't ask you first to reconsider my motion to strike. I understand your rationale, but I think there's a clear case to require that any materials afforded to be submitted into the record after the July hearing have been done so by August 30th. I think Rule 5.6 of the board's procedure is clear.
Mr. Fulton, in my view, their exhibits help you.
With that, then I'll move on to some more substance on the matter. I appreciate it, Mr. Chairman. This is a critical area variance, and forgive me for repeating something I said at our original hearing, but under Maryland law and our city's code, there is a presumption that the applicant's critical area variance request does not conform with the general purpose and intent of our critical area program. The only way an applicant can overcome this presumption is by meeting every single applicable variance criteria, and the failure to meet just a single criteria would require denial of the application. Candidly, I think many, if not most, of the variance criteria applicable here lack the substantial evidence needed to overcome this presumption. At the applicant's July hearing, the board heard from 0 experts. They heard from the applicant, the owner of an engineering company, and they heard from a significant amount of protestants. Now, only one party has offered a signed expert report concerning this application, and I appreciate that we heard additional live testimony this evening. But it's my client, Ms. Webster Giddings' expert report, which indicates that placing a foundation where the applicant is proposed would likely injure her long existing mature pine trees, which I will remind the board are also in the critical area. But I think what is perhaps the most glaring issue in this entire application is that it continues to be fraught with vagueness regarding how this 42.25% is calculated and apportioned among however many trees are being proposed for removal. On this issue, I think Mr. Zizali hit the nail on the head at the July hearing. Without some sort of breakdown showing how each tree slated for removal makes up this 42.25% sought to be cleared, I just don't think there's any way of actually evaluating whether this request is in fact the minimum necessary to afford relief. I appreciate this drawing that's been submitted by the applicant. It shows shading, which purports to be that 42.25%. But like I said, it contains no breakdown. It doesn't show why it couldn't be 40% or why this, one of these 3 to 6 trees which are being proposed to remove might actually not need to be removed. If that's not clear cut in a variance request in the critical area, then I think that criteria fails and this application should be denied.
All right, Mr. Scruggs.
I respectfully disagree with Mr. Fulton. He and I have a good working relationship, and I respect his position and the fact that he's in an untenable spot of having to defend a protestant who I believe has spurious intents in defending against this matter. But respectfully disagreeing with him, we've now just had 2 experts. To say that Mr. Forgan's not an expert is insulting to Mr. Forgan. To say that Mr. Petticord is not an expert is insulting to both of them, which is to say that we have produced on the record during evidentiary hearings on this expert testimony to establish that this is the minimum necessary required variance to the lot coverage. And again, this is a limited scope variance. This isn't for anything other than saying that we need a minimum variance to the minimum lot coverage in the critical area to allow for the erection of a single family home that everyone else in the community is entitled to have. It's a canopy coverage issue. It's a minimum request. And if I've said that multiple times, it's because I need to stress that. This is the least amount of relief necessary to allow my client to build his home that every other person in the community has. And the fact that it's supported by the city of Annapolis, it's supported by an arborist, it's supported by an engineer, all experts in this field, it suggests to me that, and if I sound slightly frustrated, because one of the reasons we submitted the drawing with the color coding is Madam Board Member Chen asked for us to color code out and show to the board specifically what the canopy looked like, where the houses were, the specific trees. We did this drawing very narrowly tailored to Member Chen's request. And I think that that needs to be taken into consideration, the fact that this was done showing the sidewalk, the driveway, the total area represents 76.90 of the total 42.25 canopy cover removal. And so that one tree on the property is literally almost 70 to 80% of what it is we're requesting. That's the tree. So for any argument to say, oh, we haven't shown what we're looking for is not correct. And it's not accurate. It's not truthful. So when you look at this document that the board itself requested, and we had our expert, Mr. Forgan, adequately detail percentages as requested, it shows that, again, this is the and I appreciate Mr. Gallagher's comments, but saying that this benefits Mr. Fulton is simply not correct, or his client, because we did everything the board asked and we showed what accounts for the canopy coverage, which is this one tree. Without this one tree that's dying, as Mr. Petticord said, is in a failure state, we don't need the variance. It's one tree. It has nothing to do with the pine trees, which are, again, dying. They will die. Whether we do something or not, whether we build here or not, these pine trees are going to die in the future. So and as he testified, they're more of a threat to the protestant's house than they are to my client's lot. So when you look at this color-coded diagram, every single one of these things here shows exactly what the tree canopy is and why it's needed. This is the minimum relief requested. It hurts no one. It doesn't impact any of the neighboring properties or the community at large. It's consistent with the neighboring community at large, conforms with every other regulation that the county may have as currently applied for. And again, I think that's what needs to be stressed is This is just for the canopy coverage. There will be other requirements for mitigation in terms of building. There will be other requirements for grading. There'll be other requirements for permitting for everything. This is just for the canopy coverage. It's a limited request. This is not broad spectrum. And I think given the arborist reports as submitted, experts that were here to testify and answer questions, and Mr. Forgan, who is an expert answering questions, that we have submitted the overwhelming weight of evidence that suggests that this application should be approved as submitted, and we specifically request that it should be.
All right, thank you, Mr. Scruggs. Ms. Corrace, are you interested in chiming in on this, or Kim?
I'd just like to, I guess, agree with what Mr. Scruggs said. It's if that big tree that's dying on the lot were to fall down tomorrow, they could come in for a grading permit with no variance needed.
Right. Okay. Okay. So any more questions from my colleagues on the board?
No, Mr. Chair.
All right, well, let's see what we can do. Would anyone like to lead the discussion?
I have some thoughts, as I usually do.
Good.
I'd like to start with the pine trees, right? Because I had a lot of questions about the pine trees, and the pine trees are important in the discussion here. And first of all, I'd like to start off with say that I do have some experience. I'm not a certified arborist, but I have removed dozens and dozens of trees. I'm familiar with it. I've been in the contracting business my whole professional adult career. I recognize the state of these trees, and I do have an opinion about them, but I'm not going to enter my opinion. We will just rely on the testimony by the experts. The pine trees that are 6 or so feet away from the existing property, the existing dwelling, are relying on the soil that's to the left or on the property that they exist, and to suggest that building a new house that's twice the distance away is somehow infringing on those trees' rights it feels to me a little disingenuous, because you're saying it's okay for me to have a house 6 feet from a tree, but I'm not going to allow you to build a house 12 feet away from the trees. So I don't like that relationship, right? Secondly, I would add that, yes, those trees are not great specimen trees. Tall, leaning, white pine trees close to a property like that are on a short timeline. But that's neither here nor there. The silver maple, again, I fall to the reasonable, could they come in now? Could they bring an arborist now and say, listen, this tree's dying. I own the property. I only want a permit to take the tree down. Would the arborist look at the tree and go, we agree with you. The tree needs to come down. Could somebody appeal that decision? Is that essentially where we are? Is this an application? Forget grading, forget the house, forget everything. If the applicant came in to simply remove the tree and the arborist issued a tree cutting permit, which they do for trees of a certain diameter over a certain distance from the ground in front of the property, et cetera, would the arborist agree to a tree removal permit full stop on that silver maple? And I believe they would, given its condition. Right? Would that be a path to the variance or the next step in the variance in the application process? I think it probably would be. I view the removal of trees of this size skeptically. I want them removed absolutely as a matter of last resort. I want them to be mitigated in their removal, et cetera. But I feel a lot of compelling arguments, both that these trees are at the end. They've done their service to Annapolis, the clean air, the clean water, et cetera. They are at the end of their service life as a silver, which is not a great tree, as a silver maple goes, right? So if I break the relationship between the utility and the life of the silver maple as a thing, as an entity, and the request here, does that clarify my motion, my decision? And in some respects, it does, because of the old, what makes the most sense? What is our charge here? What is practical? Every other neighbor had the opportunity to build their houses on these lots before the trees grew. This lot was ignored. A tree grew. The tree lived its life. And now we're in this weird 5-year window when this tree is too big to take down, but nearing the end of its life. Should we just all reserve judgment and come back in 5 years when it falls down on its own natural course and come back and view it then? I think that's unfair to the applicant. And I think it's really not the way we should be conducted. We have to keep the larger context and the larger picture in mind. And I don't like the idea of taking the trees down. I don't like being asked to vote on whether it's okay to take trees down, but that's what we're being asked to do. That's my thoughts.
All right. Anyone else? Thank you, Christian.
No, sir.
Mr. Chairman, Mr. Zali knows I have great respect for him. We've been together on this board for many years, but I don't follow him necessarily down this course. I think Mr. Fulton's argument that all the criteria of the variance have to be met, in my mind, there is the damage to the pine trees along the side of the Giddings property would likely occur, that it could be injurious to her property if those trees were lost, if they were damaged. So I just don't think that criteria is being met. That I do believe that given the situation of those trees and the report that Mr. Fulton put forward from his arborist, that there is some life left in those trees. Also, I'm not convinced that the applicant met the criteria for telling us what trees really need to be removed and what amount of canopy space, if they're meeting the proper criteria for remaining canopy. That really didn't come out to me today either. So for those reasons, I would have a hard time proving this variance.
Mr. Hector? Thank you, Michael.
I have no comment. I'm just going to go ahead and vote.
Okay. All right. I sort of regret that we've spent all this time going over the arborist report, but those are the new documents, and I thought we needed to understand them. And I say that because I think it's not where we really need to focus. I think it's a mistake for us to get drawn into what trees can be removed and where and what size house can be built. That's really what the planning and zoning department does. And so I would focus elsewhere. The applicant clearly has a substantial burden of demonstrating hardship, minimum necessary, and that the variance is consistent with the spirit of the critical area law. And I think we have real problems there. The applicant wants to build a house that's at least a couple, 300, 400, 500 square feet bigger than the average house of on the neighboring similar lots. And that comparison doesn't even include a 2-car garage. None of the houses on similar lots have a 2-car garage. Some of them don't have any garage at all. And the applicant's also proposing a nice wide impervious driveway and an entry walk and a deck on the back. So however you look at minimum necessary, that seems to me to be more than minimum necessary. The applicant, you may recall at the last hearing, I asked Mr. Mona if they had considered what they could build, what kind of house and where they could build it on the lot, if they didn't get this variance. And his answer wasn't perfectly clear. He conferred with counsel, and I would construe what he said as either no, they hadn't considered it, or they had, but they don't want to tell us. I also asked them if they had considered in developing their plan alternative means of avoiding damage to some of these trees, such as building on piers or a slab. And he said they had not considered that either. So for me, it's hard to get to the conclusion that the denial of an application to build this large house would be a hardship if you haven't really considered what the alternatives are of complying with the law in any detailed respect. And as far as consistency with the critical area law, how you can say it's consistent with the critical area law to clear basically all of the big trees on this lot and rely to meet your canopy or coverage requirements on the trees next door, which your own expert says should be immediately taken down because they're a danger and a hazard to life and property. So, I mean, be realistic. I hear what Christian's saying. If they could convince the city that that tree is in danger, and it seems to me the city forester was moving in that direction as he revised his report. Then they can do this without our variance, and maybe that's what they'll end up doing. If we turn down the variance, they can make some adjustments and come back to us, and we'll have to consider that with an open mind when they do. Something's going to be built on this lot. I hope the neighbors don't have any unrealistic expectations, and it's going to be something that they probably won't like, but that's all we can do is apply the law that we got to work with. And the way I see it, they don't come close to meeting their burden of showing a hardship, or that it's a minimum necessary, or that it's consistent with the spirit of the critical area law. So that's where I am. I'm happy to discuss those views with anyone who thinks I've gone astray. Is there a motion?
Mr. Chairman, I move that the variance 2024 0007 be denied for not meeting all the criteria as set out in the city code for the variance.
Second.
All in favor?
Aye.
Aye.
Mr. Chairman, the vote having been taken and a motion being done, we note a general objection as the vote does not conform to the standards of the Annapolis City Code, the Norfolk County Code of the State of Maryland, and the fact that Ms. Chen was not here to weigh in, as she was a deliberating body to the original matter under the record. We will object to her not being participating here. We note just a general standing objection to the board's decision, and we will request a 10-day period for a motion to reconsider with a briefing to be submitted to the board.
The rule for reconsiderations in the board's rules, you've got that. So do what you have to do. We'll have a written, the time for reconsideration runs from when our written decision is issued.
Understood. Just making the record clear for transcription purposes.
All right. All right. Thank you all. I know it's been a difficult one. I appreciate the hard work that everyone on the applicant side has put in. I know you're going to build something, and maybe you should have gone for the tree removal, because we have to apply the rules that are given to us to apply. And for the reasons I said, I just don't see it. So again, thank you. Sorry it didn't go your way. For the Protestants trip, I know you'll give them the reality that this doesn't mean it's over. It's going to continue. So,
good, Mr. Chairman. Thank you.
All right. Thanks. Is there anything else we need to deal with tonight?
So we are meeting twice in October and at least once in November.
Yeah.
Okay.
And maybe we'll get the holidays off.
Yeah.
I'll mention that some of you, I think probably all got copies from Kim. of a new standard operating procedure for the Annapolis cable TV folks that run our meetings, and those SO standard operating procedures deal with who can be heard remotely, when, with what notice, and so forth. Those are going to require some tweaks to our existing board rules. I will get to that maybe before the next meeting, but certainly within the next couple of meetings. So and so if any of you have any ideas for things you think we need to address in terms of amending the rules, it's always a good idea to do it all at one time. So let me know if they are, give me your suggestions.
Was that something that planning and zoning was supposed to get a copy of too, or no, just you guys?
No, I believe you guys have it.
Okay.
Kim, if they don't have it, please make sure they get it.
I will. I know at this point we had sent it to all the board chairs. And
yeah, I didn't see it yet.
But further down, no, and I'll take care of that tomorrow morning.
Check their security clearance before you send it. Okay.
I'm definitely insecure, so don't send it to me.
All right, is there a final motion for the evening?
I move that we adjourn.
You're getting good at that.
Yeah, you can.
All in favor?
Aye.
Oh, thank you very much. Good night, all, and see you again in the beginning of October.
2 weeks.